The Honorable Justices of the Supreme Court. Hear ye, hear ye, hear ye. All persons having business before this court are admonished to jot an eye and give their attention to the court.
Good morning. Welcome to the 11 o'clock calling of our docket today. I would ask the clerk of the appellate courts, Mr. Doug Shima, to please call the first case on the 11 o'clock docket.
Thank you, Your Honor. May it please the court. The 11 a.m. docket for Wednesday, September 15th, 2021 consists of two cases. First case to be heard on the docket is appeal number 120339, State of Kansas versus Gutierrez-Fuentes, Sedgwick County, briefs both sides. The second case immediately following will be appeal number 118792, State of Kansas versus Cameron Michael Taylor, Finney County, briefs both sides. Your Honor, the appellant in State versus Gutierrez-Fuentes, 120339 has reserved 3 minutes rebuttal time. We are ready to proceed.
Thank you, Mr. Shima. Counsel, would you please enter your appearances?
Your Honor, my name is Randall Hodgkinson. I'm appearing today on behalf of Geldy Gutierrez-Fuentes, and I'm ready for argument.
It please the court and counsel, Assistant District Attorney Matt Maloney for the state, present and ready for argument.
Thank you, counsel. Mr. Hodgkinson, you may begin your argument.
Thank you, Your Honor. This case is an appeal out of Wyandotte County. Mr. Gutierrez-Fuentes was convicted of 2 counts of aggravated battery and a count of aggravated burglary stemming from allegations regarding domestic abuse. He was also charged with rape, but was acquitted of rape. In this case, the district court imposed a 41-month sentence for aggravated burglary and a consecutive 41-month prison sentence for aggravated battery for a controlling sentence of 82 months in prison. Your Honor, I think there are 3 issues before this court. My intent today is really to argue the second and third issues mostly, although I know the court will interrupt with issues, questions about issue 1 if you see fit. But I thought I had more to add with regard to issues 2 and 3 today. Issue 2 has to do with the aggravated burglary conviction in this case.
Counsel, could I interrupt? I do have one question concerning issue 1. And that is the constitutional question wasn't raised below. Should we remand to the district court for findings if we agree with you concerning that it's presumptively prejudicial delay? Should we demand for additional findings on those other factors?
So it's possible, yes. So if the Court of Appeals said they found it was not presumptively prejudicial, and so they mostly really stopped their analysis at that point. Although they also did a prejudice analysis, I think, in there that we disagreed with. So if this court disagreed with the Court of Appeals analysis on that, I mean, we asked you, we think the record's sufficient for you to make the Barker v. Wingo analysis on your own. But if you disagree with that, if you think that there are some facts that you need more information about, or that an appellate court would need more information about, you certainly could remand it. It would depend on your, we think the record is sufficient to do the Barker v. Wingo analysis in Mr. Gutierrez-Fuentes' favor now, but I recognize that to the extent that you think there are disputed facts, you could remand it.
It just seemed that there was very little in the record on the reasons for the delay. There were multiple delays.
That there were a lot of delays. And as my colleague notes, I mean, some of them were with my client's understanding and permission, but a lot of them were not. So to the extent, again, Your Honor, if you said that's really important for this analysis, what ends up being a legal analysis, but we know that there are facts that can be intertwined in it, then yeah, remand to the district court to resolve those facts would be appropriate.
Thank you.
With regard to issue 2, the aggravated burglary case in this count in this case, it's an issue as the court knows, I've raised similar kinds of issues to this before, and this court has reached issues like this before. The gravamen of aggravated burglary is the unlawful entry or remaining in some place with the intent to commit a specified crime. And it's that gravamen of unauthorized, unlawful entry or remaining in a place that it makes it a burglary. It's what makes it different. That's why I can be convicted of burglary and the crime that I might commit within a particular place. It's the unauthorized entry into the place that makes it a crime. The question in this case was whether or not the state proved the element of the crime of burglary, that Mr. Gutierrez-Fuentes was unauthorized to be in the house, in the apartment in this case. And there's a sort of a tension here between this court's decision and a case like Vasquez, where the court recognized that there may be situations where a person doesn't want somebody to be in the house, but that's a different question than the legal question of, is the person authorized to be in the house? And then other cases, tension with cases like Williams, where this court has said, where the defendant puts on no evidence that they have any property interest in the house, that other evidence like forced entry could be evidence that they're not authorized. And so I guess the Court of Appeals thought, and I don't know, maybe this case falls somewhere in between, but here's certainly one distinction between this case and this court's decision in Williams. In Williams, this court found, because I lost, that Mr. Williams had no property interest in that house. You said he was only a social guest. Maybe he had some things there. Maybe he was paying utilities there, but that he was not, there was no evidence that he had any property interest in the residence in Williams. But in this case, it's much more like Vasquez. There's clear evidence that Mr. Gutierrez-Fuentes lived in the apartment that was the subject of the alleged burglary in this case, that he had lived there for months. I reviewed the testimony this morning and it was clear that he had lived there. So he did have a property interest in that. Now, whether it was extinguished or not, I think that's the state's idea, is that even if he lived there, it was extinguished because she didn't want him to live there anymore. But that's, Your Honor, our claim is that's not the way the law works. Just like in Vasquez, just because somebody doesn't want you to be there doesn't mean you're not authorized to be there. That's a separate question.
Well, why is that? Unless the defendant came forward with evidence of his name on a lease, for example, or on a deed, why wouldn't the lawful owner be permitted to revoke a permission at any time?
Sure. Well, there's two answers to that question, Your Honor. First of all, even within the question you've just asked me, you've shifted the burden. You said, unless the defendant puts on some evidence that he is authorized to be there, why shouldn't that be enough? And so first of all, I would complain that that's shifting the burden. My client doesn't have to prove he was authorized. The state has to prove he was unauthorized.
Well, and I guess I would just turn that around then and say, why isn't the circumstantial evidence that his authorization was revoked by the occupant? I mean, that's all we have. We have certain. Why isn't that sufficient to meet the state's burden on appeal to demonstrate sufficiency of the evidence?
In this particular case, there's a couple answers, but my main answer would be because the state failed to prove that she has a sufficient interest in the property herself to be able to do that. And I reviewed the testimony here. I was reviewing the state's brief in this case, and the state described the apartment as DS's apartment, that this was possessive. It was her apartment. But in fact, the state never asked a single question about what her interest was in that apartment during the trial in this case. They never asked, are you a tenant in here? Do you own it? They never asked that question. It's more accurate to describe that this was the apartment that DS lived in. That's what we know from the record. They asked the question, did you live in this apartment? Yes. They never followed up with, how are you living there? Maybe she's a social guest. Maybe she's a trespasser. Maybe she's a tenant. Maybe she's an owner. But the state never put on that evidence that she would have the superior right to be able to extinguish somebody else's right to be there.
If that's all we're confronted with, or that's all the evidence that we have in the record, why isn't it a reasonable inference for a jury to draw from that circumstantial evidence that she in fact is the lawful owner of the property interest in the apartment?
I just don't think that there's any evidence. You can make inferences, but the inferences have to be based on some evidence. And I'm not sure what the basis of the inference is in this case, Your Honor.
Yeah, that's what I'm asking. It's just like, is the testimony that she lived there sufficient for the jury to make that inference? I take it your answer is no.
Yeah, my answer is no. And that the state would need to lay some groundwork for, she's an owner and therefore she has this superior right to be able to do this. Or that she's a tenant and she is the only person on the lease and she has the superior right to be able to do this. That in the situation we have no information in that regard. And as a result, our position certainly is that we do not believe that the state proved that my client was unauthorized. The state proved beyond a reasonable doubt that the DS did not want my client there. But that's a different question, just as you said in Vasquez. With my remaining time, Your Honor, I just want to move on to the third issue, which has to do with the Court of Appeals enactment of an exception to the hearsay statute in this case for something called a language conduit rule. So the situation here was that the alleged victim in this case made some statements to a police officer or to a nurse at the hospital. And at trial, the police officer and the nurse are testifying, except neither the police officer or the nurse spoke Spanish. So they didn't really know what the person was saying. They were getting these statements through some unnamed, unknown translator at the hospital. And so my client argued that's hearsay. That's an out-of-court statement being offered for the truth of the matter asserted. And that's hearsay. If they're not going to bring the translator in here, then this shouldn't be admissible.
Does it matter whether it's a translator or an interpreter situation? Translator invokes more of a proposition that the translator is taking something substantive, doing it themselves, and presenting it to the non-English speaking person, as opposed to just simply being a conduit from the source language to the target language.
I haven't thought, and I don't remember like sort of seeing any development of the difference between those things, Your Honor. So,
well, the case you cited in your brief talks about a law enforcement officer handing the interpreter a piece of paper and telling that person, give this information to the non-English speaking person. And you said that interpreter had a substantive role and that you should be able to cross-examine that person. In this case, you have a witness who doesn't speak English and another witness, and she testified, and you have another witness testifying who does speak English. And the person that you're talking about was simply there interpreting the source language to the target language.
We have no way to know that, Your Honor. We have no way to know that because we don't even know who that person is.
So should that be explored on a case-by-case basis, or are you saying in all circumstances that is a hearsay situation under our statute?
I'm saying under our statute, it's always an out-of-court statement by a person for the truth of the matter asserted. It's that the interpreter or the translator in this case saying, this is what witness is saying. And the state's certainly offering that for the truth of the matter asserted.
Does that require interpretation of the word statement?
I mean, a statement is it's a communication. I'm pausing a little bit just to really think about your question, but I don't think it's unclear that the hearsay rule statute applies to verbal communications like what was being done in this case. I mean, our position is one, the rule that's set out by the Court of Appeals, the statutory exception set out by the Court of Appeals, I mean, I can understand that there's value maybe in some sort of exception like that. Our first response is if that's true, it's the legislature's job. This is a statute, 60-460. It's the legislature's job to do that. Secondly, the things that you just talked about, we don't know because it was never brought up. And the issue of sort of this identity and credibility and reliability of this person was never brought up at trial. I'm out of time, so I'll stop.
Mr. Hodgkinson, does it, does it matter that the witness that was being interpreted, but the underlying witness that made the declaration was available at trial? How does that affect either the admissibility or harmless error analysis, if at all?
So I don't think it affects the admissibility at all. I mean, what it means is that the statements that were, perhaps made, we can imagine like there were recorded Spanish statements in this case. Could they be admitted when DS is there then in court? Yes, because the statute says if the person is there, that person's statements can come into court. You're able to cross-examine that person regarding those statements. But here, we're talking about the intermediary, the person who is purported to be interpreting in this case, that person separately. So for purposes of admissibility, no. Now, the Court of Appeals did say that, well, even if they're wrong, because the alleged victim in this case was there and was cross-examined and had similar statements to what the interpreter said she made, that it was harmless. So as it relates to harmless error, certainly the Court of Appeals found that. But Your Honor, I would just note that's a self-fulfilling prophecy, right? Well, what the person said was consistent with what happened before. Therefore, it shows, first of all, that it was accurate, and secondly, that it's harmless. And Your Honor, that's a self-fulfilling prophecy. That's the whole problem, is what if it wasn't accurate? What if the more contemporaneous statements were quite different, but because we didn't get an accurate, reliable interpretation, we don't even know that. And so that's why we think it is harmful in this case. I assume the state introduced the statements of the officer and the nurse, their recording of what the interpreter said, because it bolsters their case. Because generally, we think that a person's memory is better right after an event happens than months later during trial. And so if that evidence had been excluded, there is a reasonable probability that the outcome could have been different, particularly in light of the fact that we know the victim, in this case, the testimony of the victim, at least the jury had a reasonable doubt about some of it, because they did acquit my client of some counts in this case.
But counsel, couldn't that have been brought out from cross-examination? Because you had the non-English speaking witness, and you had the person on the other side of the translation. Can't you cross-examine DS and say, is this what you said? And she can say, no, that's not what I said.
But the problem is that we don't get to cross-examine the intermediary to say, is that what she said?
No, you have the law enforcement officer and the nurse who will testify to the translation.
Right.
And you have that as evidence, and you also have DS who supposedly said the statement. So you can cross-examine DS.
That's why DS's statements aren't hearsay. But what if the interpreter would have said, no, that's not what DS said?
No, I'm saying that's not what I said, what the other witness said. Can't you cross-examine that? What the cop said is not what I said.
Not effectively, Your Honor, not effectively. I should be able to cross-examine the declarant. That's why we have a hearsay rule.
But if you take that to the extreme, how is a non-English speaking judge supposed to sort out whether or not an interpreter made a word-for-word translation or the most accurate translation or the least accurate translation at its extreme? How would an English-speaking judge ever discern that?
I mean, the statutes provide, and in fact, in the case cited by the Court of Appeals in Van Pam, I mean, Kansas statutes provide for district courts to be able to get interpretation assistance. And by the way, I think it's reflective to look at what the statute says with regard to the use of interpreters in court. And it's not this Wild West approach that the Court of Appeals is taking to, well, so long as the person seems like so long as we don't have any reason to think they're not reliable, they must be reliable. That's certainly not the approach that Kansas statutes take to the use of interpretation in Kansas courts. And so, I mean, I don't know exactly how to answer your question, but Your Honor, to the extent that a judge is like, I need some help doing this, the statutes provide for you getting that expert help from an interpreter if you need it. I don't even know that you have to go that far in a particular case. I mean, all we're saying is bring the interpreter, just bring that person, but they don't even know who it is in this case. How can that be just?
Do I understand that you would say the truth of the matter asserted is not an inquiry about what happened? In other words, what DS's description of what happened is, but rather the truth of the matter that would be asserted would be, this is what DS said.
Yes.
Are there other questions?
Very quickly, I presume that was objected to below.
Yes.
And so if the court had sustained that objection and excluded that testimony, wouldn't the evidence have been the same? And that's the harmlessness question.
Yeah. And Your Honor, I think that, again, that goes back to this idea of, like, why did the state put in those statements? To corroborate DS's trial testimony, and to corroborate it. I think, I'm not a trial attorney, Your Honor, you can tell me more about this, but I think trial attorneys want to get the statements of people as contemporaneous to the events as possible, that those are the best statements, and that they will corroborate later trial testimony.
But even granting all of that, if what you say should have happened, which is that this portion of the testimony was excluded, it wouldn't have changed the outcome because that evidence came in through other witnesses.
But it wouldn't have been corroborated with those prior statements. It would have just been the victim's statements by themselves. And what we know is that at least on some level, the victim's statements didn't convince a jury beyond a reasonable doubt of all the state's claims in this case.
Your argument is without the corroboration, the jury would have acquitted.
The jury, at least maybe one more juror would have formed a reasonable doubt. And that's all I have to show, Your Honor. That's all I have, Your Honor.
I have just one more question, Your Honor. There was no confrontation clause or constitutional issue raised here, was there?
The objection was on hearsay grounds, Your Honor, not confrontation clause. That's an interesting other issue, but not one before us today because of the objection made.
Any other questions? Thank you, counsel. Mr. Maloney?
Thank you, Chief Justice. May it please the court, Assistant District Attorney Matt Maloney for the state. I'll begin with issue 2, the sufficiency of the evidence for the aggravated burglary conviction. And though this court is well aware of it, I do think it's worth discussing or at least mentioning the standard of review here, which of course is that the evidence is to be viewed in the light most favorable to the state and determine whether a rational jury could have found the defendant guilty. This court is not to reweigh the evidence or look for other possible verdicts that the jury could have reached. It's simply to determine whether the evidence that was presented was sufficient to support a conviction. And as Justice Stegall pointed out in his questioning, of course, all convictions can be, all charges can be proven through circumstantial evidence. Today, what opposing counsel has focused on primarily in trying to contest the authority issue is whether the victim herself had the authority to exclude the defendant from the residence. He points out that they had been dating and that there was a time period during which the defendant did live with her in this apartment. But he argues that there's no evidence that this was in fact an apartment that the victim had a property interest in. I would point out that as I cited in my brief, record volume 16 at page 55, the victim did testify that at the time that she met the defendant, that she lived in this apartment by herself, and that then about a week later, he moved in with her. Now, counsel is correct. There was no direct testimony from the victim saying specifically what her lease situation was. There was no rental agreement that was put into evidence. All of those things would have been terrific evidence for the state had we put that in. But the fact that there was not a rental agreement or specific testimony asking her the terms of her lease, that does not mean that the evidence that was presented was not sufficient, especially viewed in the light most favorable to the state, recognizing that circumstantial evidence is sufficient to support a conviction. I think that any juror, any reasonable jury hearing this evidence would have plenty of reasons to believe that this was in fact an apartment that she owned or leased, and therefore had the authority to exclude the defendant. Yes, I don't dispute opposing counsel's assertion that there was evidence indicating that the defendant had lived at the apartment at one point, but clearly he was not authorized to enter on the day in question. And I cite Williams as the case that I believe that this is most analogous to, because it's a similar situation. She did revoke his authority to enter. He came back, and very clearly, I think the defendant himself implicitly recognized that he did need her permission. He came back, he went to the window, he asked to talk to her. He had already come to remove his belongings at her demand. So very clearly, the defendant himself knew that he did not have permission to be there, that he needed her authority in order to enter that apartment. The very fact that the only way he gained access to the apartment was by breaking the door is further evidence, as this court said in Williams, that forcible entry is one piece of evidence that can support a conclusion that the defendant did not have authority to be there. So in summary, the fact that the defendant had lived with her permission in the past does not mean that on the day in question that he had the authority to enter the apartment. If counsel's argument were accepted, then essentially anybody who has ever lived with a significant other for any period of time would be entitled to come back to that residence, no matter how long it's been since the relationship ended and the other person terminated their authority. In this case, it happened to be within a day or two of when the relationship had ended, and she had told him that he was no longer welcome and demanded the key back. But by counsel's rationale, what if it were a year later? What if it were 5 years later? The fact is, by the time that he went to that apartment on that particular day, she had clearly revoked his authority to be there. He knew that. That's why he had to break down the door in order to gain access. So while counsel can certainly point to other possible ways that a jury could have interpreted the evidence, that is not this court's task in looking at a sufficiency of the argument, of the evidence argument. So
Counsel, doesn't that really beg the question, though? I mean, I can tell my husband he has to leave, but he doesn't have to leave. And isn't the defense's point that you didn't have sufficient evidence to indicate that she had the right to tell him to leave?
That's certainly counsel's argument. Our position simply is, again, that the circumstantial evidence shows otherwise, that this was her apartment, that she had granted him permission to live there with her for a period of time, and that she had then revoked that permission. Clearly, in your hypothetical, that would be more akin to the Vasquez case that the defendant cites, where it's a shared marital residence, it's a married couple, and while one spouse may no longer want the other person there, there's no indication that that spouse has any greater property interest, or that the defendant in that situation does not have a property interest anymore. But here, this was not a marital residence. This was not a married couple. There's no indication that the defendant was paying utilities or on any lease, or that there was anything tying him to this apartment other than the fact that she had granted him permission to be there. So once that permission was revoked, her apartment was no different than any other apartment in that same complex. If he had shown up at her neighbor's house on the same, or neighbor's apartment on the same day, I don't think anybody would reasonably say that he had permission to be there. Likewise, in this case, once that permission was revoked and she was no longer voluntarily letting him stay there, he had no property interest. Whereas in your hypothetical, your husband, assuming that you're both on the mortgage and that you both have access to a marital residence, then certainly we wouldn't suggest that one spouse would have the permission to exclude somebody just because they've had an argument. But that is a different scenario. And as I argued in the brief, that's why our position is that Williams, not Vasquez, is the case that most clearly resembles the situation in this case before the court. If there are no other questions on that issue, I would move to issue 3, which is the hearsay argument. Again, starting with the standard of review, this is an abuse of discretion standard. I think that clearly our position is that this court should follow the language conduit analysis that the Georgia Court of Appeals set forth in the opinion that we cited in our brief. And I would note that as the court cited there, the majority of courts and jurisdictions that have addressed this do apply that rule. There are some courts that do not, but the majority do follow it. And our position, yes, Your
So
Honor.
what would you suggest the court is to do if an objection is made? Objection hearsay, no interpreters here.
I think that the analysis in the case from Georgia and that the Court of Appeals followed in this case does address that to some extent, as far as indicating that the key is looking at whether there is any indication that the interpreter would have any motive to fabricate or distort what the person said, and if there's any, and or whether there's any indication that the interpretation was in any way inaccurate. And so factors would include, like in this case, the interpreter was an interpreter that was it was provided by the hospital. This was not a law enforcement officer. This was not anybody where there could be a reasonable argument that this person had some motive to fabricate in order to help the police along. This was a person that was there at the hospital. And while some of the statements were made to an officer, again, it was a hospital employee, and then the other statements were made to a nurse who was receiving the statement largely for treatment, medical treatment purposes. So again, there'd be no reason for there's certainly no indication, or there's never even been an allegation by the defendant that this interpreter had a motive to fabricate or distort. There was no argument made that this person lacked the qualifications to provide an accurate interpretation of what the victim said. So those would be the factors that I think are appropriate to look at. And
aren't all those factors extra statutory? Or is there a statutory hook that you can point to?
I would argue, Your Honor, and I think that the Georgia case, that the language conduit rule really does speak to this, is that essentially the theory behind that is that the statements are interpreted or considered to be as if they were made directly by the victim or whoever statement is being interpreted. And in that case, the exception would be 460 subsection A, because the statement is being made by the victim and she was present and she did testify.
So that's the theory, I guess, that these really aren't even statements. It's almost as if this is a recording, a mechanical recording of what the person said.
Yeah, I think that would be one way to look at it, or the other way would be to say that to the extent they are statements, they're statements from the declarant herself, and therefore, because she was present and testified and was able to be cross-examined about this, they would fit within the 460A exception.
And is that a reasonable, given everything we know about how language works, is that reasonable?
I think it is reasonable to allow for this exception to be applied, and I think that it is something that would apply on a case-by-case basis. I know counsel was asked whether his position is that it would have to be a factual determination, or whether he's arguing for an outright ruling that this in all circumstances would be hearsay. And I believe his position is that it would always be hearsay. And we would certainly disagree. I think it's like any other exception, is that it would need to be weighed on a case-by-case basis. And where there is no indication that the interpreter had a reason to fabricate, or that her qualifications were not such that her interpretation was accurate, then in a case such as this, it would weigh in favor of ruling in the state's favor and finding that the interpreter was nothing more than a language conduit, and that this was not something where she personally gave any statements. She was simply interpreting statements given by the victim.
Mr.
But
Maloney,
how do you know? Go ahead.
I have two questions. First of all, the first question is, what would you say to appellant's statement that we have nothing to judge the veracity or the motive or anything because the interpreter was never identified?
I think that there is enough. We do know that it's a hospital interpreter. And so that certainly gives us a basis to conclude that this was a person that, excuse me, Your Honor?
Why?
Well, we know from the record that this was a hospital interpreter. And I think that simply common sense would tell us that somebody that's there provided by the hospital, whose job is to provide medical treatment, there's simply no basis for that person to fabricate, regardless of who caused the victim her injuries. That's not going to have any direct impact on how the hospital is going to be treating her. They're finding out what happened and trying to provide medical treatment. And for them, certainly for the interpreter, the identity of the perpetrator has no bearing on what she's telling the officers or the doctors who are seeking to simply find out what happened so that the victim can be treated.
Okay, and if we were to adopt the rule that you want us to adopt, the language conduit rule, would we similarly have to apply it in a situation where a defendant is speaking and you have a hospital interpreter, and the defendant is present at trial, but invokes the Fifth Amendment right not to testify?
Well, interestingly, I believe in the Lopez case that I cited, the Georgia case, I believe it was the defendant's own statements that were at issue there. I don't recall specifically whether Lopez did testify at trial. I'd have to look at that case again to see whether he in fact did. But I think the fact that it was the defendant in Lopez that testified, or that whose statements were at issue, would indicate that yes, even if it is the defendant, it does not change the fact that it's somebody that is present in court. And while he may choose to exercise the Fifth Amendment, that would be a choice that he makes. It wouldn't be something where the speaker, the declarant, is not available because they're unable to be produced, or there's some impediment to that. The defendant would be choosing on his own in that situation. So I think it would be disingenuous for a defendant to then claim that he's unavailable if he simply is choosing not to contest by taking the stand in that situation and contesting the accuracy of the interpretation.
Can you address the appellant's argument that this should be presented to the legislature, not this court, to adopt this exception?
Well, I think two things. First of all, to the extent this court agrees with my assertion that the subsection A exception applies here, then the legislature already has, because this is a statement from the declarant, in this case, the victim herself. And the legislature has already said that out-of-court statements are allowed if the declarant is available and subject to cross-examination. So I think that would be the first response. My second response would simply be that I think counsel would have to acknowledge, and I'm sure this court's aware, that case law on all sorts of matters is rife with situations where there are exceptions that have been judicially created. And I would argue that this is no different than that, that there are, like I said, plenty of situations where the court has, while case law says that statutes are to be read strictly and that language is not to be added, we all know that there are plenty of occasions where courts do just that. And in this situation, even if you find that there's not a specific statute or subsection that allows this to be considered an exception, I don't think that there's anything different in this case with the appellate court finding that an exception does apply based on this language conduit rule. Really, the purpose, as your honors pointed out, the victim herself testified at length. These officers testified at length. There were multiple avenues available for defense counsel to explore the statements that were made to the interpreter. And ultimately, as far as harmless error goes, while we're clearly not conceding error, counsel pointed out that the state must have introduced these statements for a reason, that they felt that it bolstered the state's case. Even granting the fact that it's likely the state did feel that introducing these statements helped its case, that is far from showing then a reasonable probability that but for the translator or the interpreter's statements that the result of the proceeding would have been different. Had these statements not been allowed, we still have the victim's testimony. We had statements that she made to a Spanish-speaking officer. We had the medical testimony. And again, the victim herself testified as to what happened that day. So while we don't concede error, we would argue that even if this court were to disagree with that based on the overwhelming evidence that was presented here, that there is no reasonable probability that the verdict would have been different.
Counsel, how would you, Chief, may I ask another question?
Certainly.
Counsel, how would you address the court's interpretation in United States versus Charles, which refused to accept the language conduit rule, finding that really any translator or interpreter translates concepts and ideas from the source language to the target language, and that always involves some kind of judgment on the part of the interpreter, and that therefore the interpreter does give a different voice and should be able to be cross-examined. How would you address those conclusions?
I'm not familiar off the top of my head with Charles. I'm not sure whether the defense has ever cited that case. So off the top of my head, I think what I would say though is that the same would hold true largely, even if it were a statement, even if we didn't have the language barrier issue. In other words, even if you're talking about a statement from one English speaker to another, there still might be some question about whether the person testifying is remembering the statement in exactly the way that it was conveyed, whether they're using the same phrasing or whether they're paraphrasing what somebody might have said. I do understand your point that there can obviously always be a question about whether an interpreter is literally verbatim interpreting what the victim said as opposed to sort of summarizing. But again, I think that there's always that possibility, even when it's speakers who speak the same language. But again, I'm not familiar with Charles, so I don't have necessarily a better response planned for that, and I'm not familiar with the context of that case. But off the top of my head, that would be my response to that inquiry.
Are there other questions? Thank you, Mr. Maloney.
Thank you, Your Honor.
Mr. Hutchinson, you reserve 3 minutes.
Your Honor, I don't think I have anything to add after my colleague's presentation, unless the court has questions.
I have one quick question. What if it had been Google Translate? The victim spoke into the officer's phone, which was equipped with the Google Translate app, and the phone translated. Would that be something that the officer could testify to?
That it's this mechanical translation kind of idea.
Well, just let's say the state puts the officer on and says, did you interview the victim? Yes. But it was in a different language. Did you use a translating device? Yeah, I used Google Translate. And then could the officer then testify to the words that came out of the phone purportedly translating the victim's statements?
I wish I taught evidence, because I know that would definitely be a question on that test. So I think my answer is no. I mean, I have to figure out who's the declarant, and I haven't gone into how sort of mechanical devices might be a declarant. I haven't studied that question.
Well, could I jump to my follow-up question, which is, that's probably, well, I guess my thinking might be, maybe that's not a hearsay problem, but could it be a different evidentiary problem, like a foundation problem?
Absolutely. And that's exactly right. That even in that case, I mean, I hope as a defendant, I have the opportunity to find out, well, I want to know how that works. And I might want to have an independent expert tell me how accurate is Google Translate, because I don't know, and I don't know that.
So then that leads to my last follow-up, which is it possible that the wrong objection was made in this case? That in fact, the objection was to the foundation of the translation, not to hearsay?
It's not necessarily, I'm not sure it's an either or proposition necessarily, Your Honor. I mean, it could be both. I mean, particularly if you were dealing with more of a mechanical situation. I agree with you. I sort of go down the foundation road, but I don't think it's an improper objection in this case. It was still, in this case, it's not a Google Translate. It's a person making a verbal communication, which in every reasonable interpretation, I would think is a statement. So I think it's a proper objection in this case. Thank you, Your Honor.
What do you say to Mr. Maloney's argument that we don't need to recognize a new exception? It's a reasonable construction of subsection A, 460A. I mean, I don't think it is a reasonable construction, because you're talking about a different person. I mean, if that was true, I don't even understand when hearsay. All hearsay is somebody reporting what somebody else said, right? That's what every declarant ever does. And so to the extent that that solves the problem, we're not going to have a lot of hearsay problems in the future, because they would just say, well, they're just reporting what that other person said, and that person's here. I want the intermediary. There can be 2 layers of hearsay. And that second layer is the problem in this case. It doesn't solve the problem.
Is it correct from your perspective that the only way to get to that, to the state's view, is to equate the translator with Google Translate, essentially?
With a recording of some sort. And I think, yeah, and Justice Wilson, when I was thinking about your question a little bit, and like my colleague, I don't have the facts of Charles in front of me, but the things that you were talking about from it reminded me a lot of this court's language in Van Pham that said that interpreters aren't machines. There is something going on between those declarants. And that's why, for example, we have statutes that say in order to have an interpreter in court, you have to have a lot of showings. It's not just, we didn't show they weren't credible. You have to make a lot of affirmative showings as to why that person is credible and reliable. And none of that was done in this case.
But counsel, wouldn't an interpreter say, I didn't make a statement? And the hearsay statute refers to a separate statement. And the job of an interpreter is to be unobtrusive and to make as pure of a translation from one language to another such that they really don't contribute at all by making a separate statement. Wouldn't that be what they would say to your argument?
If they're doing a good job, sure, that's what they would say. Now, there's two responses to that. One, we don't know that they're doing a good job. And two, particularly in a case like this where we don't even know who this person is, we have no reason affirmatively to think that they will be motivated that way, like an interpreter in court might. Because in fact, what do we require an interpreter in court to do? Take an oath, right? That the interpreter there is saying, under oath, if I don't interpret to the best of my ability, I guess I'm guilty of perjury. That wasn't true in this case.
But aren't you asking the court to make an assumption that they weren't qualified, they weren't doing a good job, that this was somehow tainted, and asking the court to accept that without any further evidence?
Yes, in that, for example, in general, anytime any party is asking for application of an exception, the burden is on them to show that that exception should apply. And so yeah, I guess I am. I mean, the hearsay rule, you talk about exception. What are they? A BV of hearsay exceptions? With the legislature knows how to make exceptions to the hearsay statute, but in every one of those, it's the burden of the person wanting to use that exception to prove it. And so, yeah, if they don't prove it, then the assumption is it's not proved.
But
And
your
that is what I'm
assumption,
asking you to do.
isn't your assumption that it is a separate statement?
It's that there's separate statements, that there's a statement from the victim, alleged victim, to the interpreter, and then from the interpreter to the police officer, in this case, or the nurse. And we don't even know. I don't even know what translator they used, Your Honor.
Any other questions? Thank you to both counsel for your arguments this morning. We will take this appeal under advisement. This time we will have a transition between the two cases as the attorneys on this case leave us, and we bring in the attorneys for the second case on the docket. Mr. Shima, would you call the second case, please?
Your Honor, may it please the court. The second case for this morning is appeal number 118792, State of Kansas versus Cameron Michael Taylor, Finney County, briefs both sides. Your Honor, the appellant has reserved 3 minutes rebuttal time. We are ready to proceed.
Thank you, Mr. Shima. Counsel, would you please state your appearances?
The appellant Cameron Taylor appears through Casper Shire, Kansas Appellate Defender Office, present ready for argument, Your Honor.
May it please the court, Thomas Ellis, Assistant Finney County Attorney for Appalachia State of Kansas, present and ready to argue.
Thank you, counsel. Mr. Shire, you may begin your argument.
Thank you, Your Honor. This case started when Cameron Taylor was stopped by law enforcement walking down the street in Junction City. At trial, Cameron's jury heard two very different accounts of what happened after Cameron was seized. From Cameron, the jury heard that officers pointed a gun at him, physically assaulted him, and unlawfully arrested him. He attributed this treatment to an earlier trial where he had been found not guilty of battering a law enforcement officer. From law enforcement, on the other hand, the jury heard that Cameron was searched, that marijuana was found, that Cameron resisted an arrest, attacked the arresting officer, and later in the Finney County Jail made a threatening statement. There were a number of law enforcement officers involved in this case that had access to recording devices, but none of the events leading up to Cameron's arrest were recorded either on audio or on video. At trial, Cameron was convicted of felony possession of marijuana, criminal threat, and battery on a law enforcement officer. The Court of Appeals took up this case and found the seizure that set the whole thing off was unlawful at its outset, reversed the drug conviction, and ordered the marijuana suppressed. The Court of Appeals also found 4 additional trial errors, including 2 violations of in limine orders and two instances of prosecutorial error in closing argument. Neither party petitioned those portions of the Court of Appeals ruling. But the Court of Appeals also held that on the remaining 2 charges, Cameron had not been denied a fair trial on the cumulative effect of the errors the Court of Appeals found and denied him further relief. We have asked this court to review 2 portions of that cumulative error analysis. First, whether the Court of Appeals should have considered the wrongfully admitted marijuana evidence in its cumulative error analysis. And second, whether Cameron did in fact get denied a fair trial by the cumulative effect of these 5 errors. Our argument today at its heart is a very simple one. This wasn't a fair trial. It wasn't a fair trial because it was a credibility contest that was replete with unlawful attacks on Cameron's credibility. And the primary problem with the Court of Appeals analysis in this case is that it overlooked the prejudicial effect that all of these errors had on Cameron's credibility with his jury. And all of the errors in this case did go to credibility. The in limine violations wrongfully alerted the jury that Cameron had been on law enforcement's radar not just once, but twice in the week leading up to his arrest, essentially alerting the jury that multiple times he'd been around town suspected of having large amounts of methamphetamine and a .380 handgun. There was a second in limine violation that wrongfully alerted to the jury that, at least in the opinion of the arresting officer, the area where Cameron had been arrested was a high crime, high drug neighborhood in Garden City. And all of this was evidence that never should have come in. There were in limine orders in place. The district court had already found that admitting this evidence was going to be more prejudicial than probative. And all of that evidence, particularly when considered together with the marijuana evidence, combined to essentially make Cameron look like a drug dealer, to look like somebody who was a career criminal, and to look like somebody whose word couldn't be trusted by this jury. And this court has, in its KSA 6455 case law, has looked at the effect that other crimes evidence, very much like what we've got here, has on the ability to convince a jury that your testimony is credible. And the state got the full benefit of those credibility attacks in this case. The prosecutorial errors in this case also went to credibility. The state, in closing argument, essentially set up a straw man by saying that Cameron had claimed that law enforcement officers had held a gun to his head. He didn't say that. The district court agreed that he didn't say that, and that's demonstrated by the fact that when defense counsel objected to this argument as a misstatement of the evidence, that objection was sustained. But the straw man was much easier to attack than Cameron's actual testimony. And that's exactly what happened. The state argued that Cameron had accused officers of holding a gun to his head and explicitly told the jury, quote, "You've got to determine whether or not that's credible." And all of this happened in a case where the state was relying almost entirely on law enforcement testimony to meet its burden. The question was whether Cameron's testimony created reasonable doubt that the state had carried that burden. And there was no body cam footage on either side to corroborate anybody. And in this day and age, that weighs against the state. The cumulative effect of these errors were not harmless, and this court should reverse the 2 remaining convictions. I'd like to step back and talk a little bit more about the wrongful admission of the marijuana evidence, because in addition to the credibility concerns that I've already detailed, I really think that by bringing that evidence in, you change the whole dynamic of this trial. Essentially, the case that the state put on was that they saw Cameron walking down the street. They had information that he might have meth and a handgun. They stopped him. They found some marijuana. They arrested him, and he flew off the deep end. That was the state's theory, greatly abbreviated in a nutshell. If the marijuana evidence doesn't come in, this case starts in a whole different way, because now law enforcement is stopping him without cause, is unlawfully arresting him, and is claiming that after that, Cameron goes off the deep end. So it just ends a lot more when officers are forced to own up to unlawful activity on the front end of the case. It gives a lot more weight to Cameron's claim that there was unlawful activity on the back end of the case as well. So taken together, especially with the repeated attacks on Cameron's credibility, Cameron was denied a fair trial. That's the bottom line. Cameron was denied a fair trial in this case. And if this court doesn't have any questions, I'll save the rest of my time for rebuttal, Your Honor.
Are there any questions? Okay. Thank you, counsel.
Thank you, Your Honor.
Mr. Ellis?
Thank you, Madam Chief Justice. May it please the court, Tom Ellis for the state. Looking back at it, there's a little more nuance to it than Mr. Scheer provided. I have the additional benefit of being second chair on this case when it was at the trial level, so I remember some of these things. Just to bring up the prior proceedings of how we got here today, off of the appellate court decision, there was a petition for review, and the state did not seek cross petition. But given Mr. Scheer's arguments, I am ready to go into those errors alleged, both from the presentation of evidence and the closing arguments. But before we go too far, the relief requested here seeks to add the error of the marijuana into the cumulative error analysis, along with the errors in the case in chief and closing arguments. But if we go back and look in the record contained in volume 1, I believe it's page 142 in the record, it's instruction number 6. Now, there was an instruction given to the jury previously that said each crime charged against the defendant is a separate and distinct offense. You must decide each charge separately on the evidence and law applicable to it, uninfluenced by your decision as to any charge. It goes on a little bit more, but so the jury was instructed to consider the charges independently of each other and not let the facts related to one conflate with the other. And it's the state's position that this presents an adequate safeguard to protect from that error and denying him a fair trial as to the other 2 counts. Because I believe,
Counsel,
yes,
let me make sure I'm clear. Are you conceding that the Court of Appeals should have included the improper marijuana evidence as a part of its cumulative analysis, and you're just moving us over to say, that error wasn't a big deal? I mean, the first thing is whether the Court of Appeals should have even considered the suppression error as a part of the cumulative analysis. And I think there's really very little question that the Court of Appeals needed to put all of the errors into one bucket. Now, whether that still equates at the end to reversal is a different question. But I just want to get us clear that you're conceding the panel needed to throw the suppression issue into the cumulative analysis.
No, and Justice, I'm sorry if I conflated that point. I'm not conceding that should have been thrown into the bucket, because I believe the Court of Appeals also went on to say that the facts and the way it came in at trial, they were sufficiently divorced from one another so as not to influence the remaining problems with it.
Does that rationale make sense to you? Because I'm having trouble tracking it. It seems to me that once you've decided that it was a big mistake, such a big mistake that you reversed the conviction, a big mistake to introduce that drug evidence, that's got to impact how the jury is looking at this defendant under all the other charges, right?
As to the marijuana affecting the battery on a law enforcement officer and criminal threat?
Sure, because of the things that Mr. Shire has talked about, the credibility of the defendant, et cetera. That the fact that he was holding marijuana, as far as the jury was concerned, seems that it had to impact things, right?
I don't believe so. I don't think it had any bearing on it, because what it later came down to, as previously stated, was the contest of credibility. So being able to divorce the marijuana from what happened later, because there was a period in time when they found the marijuana, arrest was effectuated, and then there was the conflict between the appellant and the officers who responded on scene. And the finding previously was that it wasn't so much as to taint the convictions for the battery on a Leo and criminal threat. And I'm trying to find the specific language. I had it here in front of me. I'm sorry, Justice, I couldn't find that spot.
Can we start at what your understanding of what entails a cumulative error analysis? Because isn't that analysis start with an appellate court, us aggregating all the errors, including individual harmless errors, and then making a determination whether the cumulative effect of all the aggregate errors denies a right to a fair trial? Isn't that where what cumulative error is and where we start? So explain to me how we would not include the error that you're saying shouldn't be a part of the cumulative effect.
Okay, so I think I understand it better. So in taking as a whole that the marijuana being presented should be presented as an error, even taking it as a whole, breaking down all of these errors as they happened, it really didn't have a bearing on the battery on a Leo, because there was a lot of evidence about the fight and the criminal threat that came well after the marijuana. Going into it, we had discussed previously presented when the actual fight occurred, the injury sustained by Officer Armenta, and then what occurred going up the Sallyport into the jail, what entailed that. Didn't really have much to do with the marijuana. And I again harken back to where, they did have the separate instruction to consider all these facts separately and independent of one each other, not go into one offense or the other. And even with the errors alleged, I think the one they had the biggest problem with was the high crime, high drug area neighborhood reference, which I believe came in, that was in the rebuttal case after Mr. Taylor had testified. And so we were trying to clean up some of the details about what happened that day, what was occurring on the street, what it looked like, and where they were at. It wasn't sought to elicit that kind of testimony in violation of that motion or the order in limine. not to characterize the neighborhood. It was a mistake on the part of the testifying officer. We were just simply looking to have residential neighborhood be testified to. And immediately, you know, there was a contemporaneous objection, and then the state, we sought to have the jury admonished not to consider that as part of it. And the court gave specific instruction, admonition to the jury not to consider that characterization. The other errors as to when,
excuse me, Mr. Ellis, but did the Court of Appeals ever consider the admission of the marijuana evidence as part of its cumulative error? I understand the language that you were talking about initially suggests that the Court of Appeals said that that evidence didn't necessarily amplify the other errors, but did it consider the effect at all of that error in isolation to begin with?
I do not believe it did, Your Honor.
Counselor, do you agree that as we sit here today, given the failure of the state to file a cross petition on the errors, that the only question we need to answer is whether the state, as the party that benefited from the errors, has to establish beyond a reasonable doubt that the errors' cumulative effect didn't impact the trial outcome?
I'm sorry, Jess, I didn't quite catch that question.
Can we agree that the question that we have to answer is whether you have is that you face a reasonable doubt burden to demonstrate that all of these errors did not affect the trial's outcome beyond a reasonable doubt?
Yes, we can agree to that, Judge, or Your Honor, sorry. And, you know, as part of that evidence demonstration, we get into the qualms about, you know, it was 2017 at the time of the offense. And I believe Mr. Shearer referenced Junction City in his opening, but just so we're all clear, it was Garden City, America. Part of that,
I think perhaps somewhere you became muted, Mr. Ellis.
uh-oh.
I'm not sure how that happened.
My apology. I think it got stuck with my space bar. I apologize for that. But we go back to the evidence presented, and, you know, there wasn't the dash cam or the body cam, but it was one of those days. It was one of those instances in which it wasn't available. The dash cams, just as it would happen, the vehicles were all pointed in the wrong direction. It wasn't a normal stop where lights and sirens are activated and it switched it on automatically. The prior testimony also was that Officer Colburn had been training that day, and where his mic pack would normally be was a dog training device thing. So this is kind of where some of that went in. But regardless of that, we had the testimony from both Officer Colburn and Officer Armenta as to the events in question that day. It was further documented with the photos and the documentation of the injuries to Officer Armenta's lip and his finger. We also included exhibits about the soiled pants, which accounted for the fall. And I bring all that up because part of the version of events that Mr. Taylor presented relayed an instance that completely changed the way in which those injuries would have resulted or the soiling in the pants would have occurred. So, and as we wrote in our responsive brief in the lower court, that we were of the position that we did have overwhelming evidence to sustain the conviction on the battery of a law enforcement officer and criminal threat.
Do you agree your evidence was really a credibility determination? You have very little to corroborate the officer's testimony, and the conflicting testimony is the defendant's. That's why it's a credibility fight, right?
That is correct. But taking all these things into consideration, we still harken back to that jury instruction that they were previously advised that they're supposed to consider these things separately. So even if we do assess it as error, the marijuana having bearing on the credibility of the defendant, I don't think it's been met to warrant reversal if you throw that into the bucket with the other 4 alleged, because the other 4 errors, it wasn't held to be these earth-shattering errors. And I harken back, there was one line in the appellate decision about the defendant is entitled to a fair trial. He's not entitled to a perfect one. I believe that was quoting State v. Bly. When we tried to do everything we could to make sure it was a fair trial, it came down to the credibility contest. We believe the instructions were sufficient to insulate from any further review or consideration of the marijuana having bearing on his credibility for the battery on a law enforcement officer and criminal threat. And if there are no further questions, I would just ask this panel affirm the holding of the appellate court. Thank you.
Thank you, Mr. Ellis. Mr. Schreier, you reserve 3 minutes.
Thank you, Your Honor. And I quickly want to touch 2 things. First, I want to talk a little bit more about the second in limine error, the high drug, high crime in limine error, largely because I think it encapsulates why this trial was not a fair trial. It was not just imperfect, it was unfair. On the first day of trial, the state had asked for permission to put on this testimony that it was a high drug, high crime area. That was denied. When the officer was testifying, it looked like he was heading that direction. Sidebar, the state was told, don't ask this question. The officer was told, don't answer this question. And then the next day in rebuttal, that's exactly what happened. The state asked, what kind of neighborhood is this? The officer replies, it's a high drug, high crime area. I don't know what the intent there was, and I don't care what the intent was. The intent does not matter to us. The result is that Cameron Taylor did not get a fair trial in this case. That's what matters to us. Also, the state insists that the testimony of law enforcement officers is overwhelming evidence that required a conviction, and that renders these harmlessness errors, renders these errors harmless. Imagine that the roles were reversed. Imagine that these law enforcement officers were on trial for assaulting Cameron based entirely on Cameron's say-so, and that trial was infected with errors. Would that testimony, Cameron's testimony alone, insulate those verdicts from being reversed due to cumulative error? And if the answer is no for Cameron, the answer has to be no for law enforcement as well. We do ask this court to find that Cameron did not get a fair trial in this case, to reverse his convictions, and to remand to Finney County so that Cameron can get a fair trial. Thank you.
Are there any questions? Thank you to both counsel for your arguments this morning, and I guess this afternoon as well. We kind of lapped over. We will take this appeal under advisement. Court is now in recess until